You know the scene. It's practically baked into our cultural DNA at this point. The courtroom is silent, all that gleaming wood paneling, and the tension is just you can't breathe. The music swells, the lawyer slams a folder down, gives this perfect blistering monologue, and then boom, the jury gasps. The verdict comes in. Millions and millions of dollars. Justice is served on a silver platter.
It's the ultimate payoff. It's why legal dramas have been a thing for, what, 50 years? We love that showdown.
We do, but I was digging into the stack of research you sent over on personal injury law, specifically Florida, but I mean, it applies everywhere. And it turns out that whole scene, it's essentially a fairy tale. It's a unicorn.
It is so rare. In the real world, if you're involved in a personal injury claim, the statistical likelihood of you ever seeing the inside of a courtroom, let alone a jury, it's incredibly low.
Which brings us to our deep dive today. We're looking at the strategic art of the settlement. Because I think for a lot of us, and I'll include myself here, there's this feeling that settling means you. You lost. Or at least you blinked, you know?
That you left money on the table.
Exactly, that you just didn't have the stomach for the real fight.
And that is probably the single biggest myth in civil law. The idea that a settlement is some kind of consolation prize for a weak case.
But looking at the breakdown of how these cases actually work, the risk, the statutes, the sheer cost, it seems like settling isn't about weakness at all. It's about control.
Absolutely. It's about calculating the vast difference between the truth of what happened and what you can actually prove inside the very rigid, very expensive system of a courtroom.
So let's unpack this. We've got legal analyses, breakdowns of Florida statutes, some really fascinating stuff on trial strategy. And the first thing that jumped out at me was this idea of the gamble. Because we think of a court as a place of logic, right? Facts go in, justice comes out.
Ideally, yes.
Mm-hmm.
But anyone who has spent any real time in litigation will tell you that a trial is, well, it's closer to a casino than a computer. When you push a case all the way to a verdict, you are introducing a massive, unpredictable variable, the jury.
The uncertainty principle of law.
Think about it. You can have all the facts. You can have the medical records, the photos, everything. But the moment you select that jury, you are handing your entire future over to six strangers who, and I mean this respectfully, would probably rather be anywhere else.
Oh, totally. They're missing work, the chairs are uncomfortable, maybe they just don't like your lawyer's tie. And they're filtering your life-altering injury through all of their own biases. Maybe they think all lawsuits are frivolous.
It sounds trivial, but those things swing verdicts. And that's before we even get to the judge. The judge is the gatekeeper. They decide what evidence the jury even gets to see. So you might have this smoking gun piece of evidence, but if the judge rules it's, say, prejudicial, it's gone. The jury never even knows it existed.
So going to trial is basically you saying, I am willing to bet my entire financial future on a process I can't control. Whereas a settlement
is a known quantity. It's a contract. You know the exact number, you know the terms, and you know the timing. You're trading the potential for that huge home run verdict, which might never happen, for the certainty of a guaranteed result right now.
Okay, so that's the big picture why. But I want to get into the weeds of the how, because this is where the sources got really interesting. It's not just juries are wild. It's about the specific hurdles you have to clear, the burden of proof.
Right. In Florida, like in most places, for a negligence claim, the plaintiff, the injured person, has to prove four things: duty, breach, causation, and the damages.
And looking at this, the first two seem pretty easy in, say, a car crash case. Duty. You have a duty not to run a red light and smash into me. Breach. You ran the red light and smashed into me.
Usually, yes. Duty and breach are often a slam dunk. But that third one, causation, that is the trap. That is where cases go to die.
This was the part that really surprised me. I just assumed if you hit me, I know my neck hurts, then you cause my neck to hurt. Simple.
But the insurance defense playbook is so much more sophisticated. Let's take a scenario. Say you're 40 years old, you're pretty active, maybe you played some sports in high school, you've worked an office job for 15 years, you get rear-ended. Not a huge crash, but now you have a herniated disc in your neck.
Okay. Seems clear-cut.
Is it, though? The defense attorney is going to subpoena every medical record you've ever had. They're going to hire their own radiologist who will look at that MRI and say, well, look at the dehydration in that disc. Look at those bone spurs.
Yeah.
That didn't happen in a split-second crash. That's 10, 15 years of aging.
So they argue that I was already hurt. I just hadn't felt it yet.
Exactly. They argue the crash didn't cause the injury. It just made a pre-existing condition symptomatic. Degenerative disc disease is the favorite phrase of every defense attorney in America.
But that feels so unfair. I was fine before the crash. You hit me, and now I'm in constant pain. What about the eggshell plaintiff rule? You take your victim as you find them, right?
In theory, yes, but you have to convince a jury of that. And if the defense has a slick doctor in a $1,000 suit saying, this is just arthritis, and your doctor saying, no, it's the crash, what have you done? You've asked a jury of 6 regular people to pick a side in a complex medical debate they are not qualified to understand.
And if they happen to pick the wrong side,
Your case goes from being worth hundreds of thousands of dollars to being worth 0. Or maybe they give you $5,000 for a sprain instead of the money for a surgery. That is the causation trap. A settlement lets you hedge that risk. You agree on a number that acknowledges the real-world injury without betting the entire farm on a jury understanding spinal anatomy.
and that risk gets even bigger, even scarier when we bring in the Florida factor. I really want to spend some time on this because this modified comparative negligence rule, it seems like it was designed to make plaintiffs terrified of a courtroom.
It definitely shifted the balance of power. Florida used to be what's called a pure comparative state. That meant if a jury found you were, say, 90% at fault for your own accident, you could still recover that last 10% from the other driver.
Okay, that makes sense. But now, under the new statute, there's this, what they call a 51% cliff.
Correct. As of a couple of years ago, if a jury finds the plaintiff is more than 50% at fault, so 51% or higher, they recover nothing. 0. It all goes away.
That math is just, it's
So-
terrifying. Because 51% isn't mostly my fault. It's barely a coin flip. It's 50-50 plus 1%.
And it creates this massive all-or-nothing dynamic at trial. Imagine you're driving just a little bit over the speed limit and someone pulls out in front of you from a side street.
Okay, well, they pulled out. They should have yielded. It's their fault.
Sure. But the defense attorney will stand up and argue, if my client's opponent hadn't been speeding, they could have stopped in time. They don't have to prove their driver was innocent. They just have to convince the jury that you were slightly more to blame than their guy.
They just have to muddy the water enough.
Just enough to get 1 or 2 jurors to nudge that number up to 51%. And remember, juries don't use calculators. They go with their gut. If the defense lawyer successfully paints you as just a little irresponsible or a little distracted, a jury might slap that 51% on you just because they didn't like your vibe.
And if they do, you walk away with absolutely nothing.
That single statutory change has effectively forced more settlements because the risk of a total loss is so much higher now.
It's weaponized uncertainty. But it's not just the fault laws, is it? The sources also pointed to changes in the evidence rules. This paid versus billed thing. It sounds technical, but the impact on the final number seems huge.
Oh, it's huge. It's all about what evidence of medical bills the jury gets to see. In the old days, what was called the collateral source rule generally protected plaintiffs. So if you had a surgery that was billed at $50,000, the jury saw a bill for $50,000.
Even if your insurance company, like Blue Cross, only actually paid $15,000 because of a contract they have with the hospital.
Exactly. Because the logic was, why should the person who caused the crash get the benefit of your health insurance? You're the one who paid the premiums.
That makes perfect sense to me.
Well, the law was changed. Now, in many situations, the jury only gets to see what was actually paid or accepted as payment. So instead of that big, scary $50,000 number, they see $15,000.
And that's an anchoring problem, right? Psychologically.
It's pure psychology. If I stand in front of a jury and I say, this person has been in agony for 2 years, but then the only bills I can show them add up to, say, $4,000, what are they going to think?
They're going to subconsciously think, well, how bad could it really have been?
It completely devalues the suffering. If the medical numbers seem low, the pain and suffering award almost always stays low too. Juries like ratios. They tend to award pain and suffering as some multiple of the medical bills.
So to bring this back to settlement, if you go to trial, you're stuck with these strict rules. The jury sees the low number. But in a settlement negotiation,
You're in a conference room. The rules of evidence don't apply. A good lawyer can look at the insurance adjuster and say, look, we both know this was a serious surgery, regardless of what Medicare paid for it. We know the recovery took 6 months.
so you can negotiate based on the reality of the injury, not the technicality of the bill.
Exactly. You can capture value in a settlement that the strict application of the law might just strip away in a courtroom. It allows for a much more holistic human valuation.
Okay, now we have to talk about the other side of this, the cost of the fight itself, because I think people have this Aaron Brockovich idea that it's all free until you win. And while that's true for the attorney's fees, the contingency fee, the costs of litigation are a whole different animal.
A huge difference. Fees are what the lawyer earns. Costs are what the case consumes. And the burn rate for a trial is astronomical.
The outline you sent mentioned expert witnesses. I looked up some average rates.
Yeah.
It's eye-watering. You're talking about doctors charging $1,500, $2,000 an hour just to review records.
Oh, easily. And if you want them to actually come to court and testify, you're often paying a flat fee, $5,000, $10,000, sometimes more for a single afternoon. And you might need 3 or 4 of them, a biomechanical engineer, a vocational expert, an economist to calculate future wage loss.
Before you even set foot in the courtroom, you could be $30,000, $40,000, $50,000 in the hole just on experts.
Correct. And who pays that? Initially, the law firm advances it. But if you win, that money comes out of your share of the verdict, off the top.
This is that net recovery idea.
This is the math that actually matters. Let's say you get a settlement offer for $100,000 today. No trial costs yet. You pay your lawyer, you pay back your health insurance. Maybe you walk away with $60,000 in your pocket.
Okay, clear.
Now, let's say you say no. You go to trial. You spend $40,000 on those experts. The jury is impressed and gives you a verdict of $130,000. You won more money. But after you deduct the lawyer's higher trial fee and that $40,000 in costs,
You end up with less than the $60,000 you could have had months ago.
you won the battle and lost the war. A settlement stops the bleeding. It caps the cost and makes sure the money goes to the injured person, not to a professional witness.
And it also caps the time. The sources mentioned the Statute of Limitations, which is now just 2 years for negligence in Florida, but also just the duration of a lawsuit itself.
Time is a massive, massive hidden cost. A lawsuit isn't quick. It's depositions, motions, mediation, trial delays. It can easily take years, all while the injured person is likely out of work, with bills piling up.
The insurance company has billions. They can afford to wait forever. The average person can't.
That leverage is very real. Settlement provides immediacy. It puts money in your hands now when you need it, rather than 3 years from now after the defense loses its second appeal.
So hearing all of this, the risk, the causation trap, that terrifying 51% rule, the costs, it almost sounds like the system is rigged to force you to settle. Like, why would anyone ever go to trial? But here's the paradox the sources kept coming back to.
The paradox of preparation.
Yes. The idea that you can't get a good settlement unless you are genuinely prepared to ignore everything we just said and take the case all the way.
It's a high-stakes game of chicken. Insurance companies use very sophisticated software to value claims. But the one variable that always moves the needle is trial risk. If they look at your file and they see a lawyer who never goes to court, who has sloppy records, and who seems desperate for a check,
They're going to lowball you into oblivion.
pennies on the dollar, because there's no threat. Why would they pay full value if there is zero risk of a jury forcing them to?
So the only way to get them to pay what the case is actually worth in a settlement is to convince them that you are fully prepared to drag them into that expensive, unpredictable courtroom.
Exactly. Preparation drives value. When a defense lawyer sees a file where every I is dotted, the experts are lined up and ready to go, and the plaintiff's attorney is filing motions like they're preparing for war, the risk calculation completely changes.
They start thinking, okay, if we don't pay $100,000 now, this person is going to make us spend $50,000 defending this, and there's a real chance we could lose even more at trial.
It becomes a cold, logical business decision for them. They settle to protect their own bottom line. So, ironically, the best settlements only happen when you prepare as if settlement is completely off the table.
It's fascinating because it reframes the whole job of a lawyer. We think of them shouting objection in court. But the real work, the real value, is in building that fortress of evidence before a lawsuit is even filed.
It's all about strategic deterrence. That's the whole job.
Yeah. So to bring this all together, if I'm listening to this, the takeaway isn't that settling is quitting.
No. The takeaway is that control is the single most valuable asset you have in the legal system.
When you hand your case to a jury, you give up all control. You're asking strangers to put a price on your pain. And strangers are fickle.
But a settlement is an agreement. It is you saying, this is enough. This resolves it. You get to close the chapter. You stop having to relive the worst day of your life over and over in depositions. You stop worrying about what a judge might do.
You get your life back.
And that's psychological closure. Just knowing it's finally over. That is often worth more than any extra dollars you might have won at trial.
It's a much more pragmatic view of justice.
Yeah.
It's less poetic than that movie scene we started with. There's no swelling music, but seems a lot more functional for actual human beings.
The legal system isn't really designed for drama. It's designed for dispute resolution. And more often than not, the most efficient way to resolve a dispute is for two rational parties to look at the risk, look at the costs, and find a middle ground.
Which brings up a final provocative thought for me. We all grew up thinking of the trial as the gold standard of justice, the one place where truth will prevail. But if the system is actually built to encourage settlement through fear, through cost, through all these rules, then is a trial actually the failure of the system?
That's a deep question. If a case goes all the way to a verdict, it almost always means one side or both badly miscalculated the risk. It means the system of rational negotiation broke down somewhere along the way.
So the justice we see on TV is actually what happens when things go wrong.
In many ways, yes.
Well, on that note, something to think about the next time you see a headline about a big settlement. It's not a retreat, it's a strategy. Thanks for helping us break this all down.
My pleasure. Anytime.
And thank you for listening. If you learned something new today, share it with a friend who loves a good legal debate. We'll catch you next time.
Hi, I'm Chris DeBerry's digital twin. Chris puts me up here when he's working on client matters. Here are our standard disclaimers. The information you've just seen is provided for general informational purposes only. It is not legal advice and does not create an attorney-client relationship. Every case is unique, especially yours. Past results do not guarantee or predict a similar outcome in your case. The facts and circumstances of your situation matter. Chris DeBerry is licensed to practice law in the state of Florida. Contacting our office does not create an attorney-client relationship. An attorney-client relationship is formed only after we have signed a written agreement. In personal injury matters, we typically work on a contingency fee basis, which means we only get paid if we recover compensation for you. Costs and fees are discussed in writing before representation begins. If you've been injured and would like to discuss your situation, we invite you to contact our office for a consultation. We'll review your matter and let you know your options. Thank you for watching.